typed, written or engraved, photographed, or cut from one instrument and attached to another. And a signature lithograph on an instrument by a party is sufficient for the purpose of signing it being immaterial with what kind of instrument the signature is made, and whatever mark, symbol, or device one may choose to employ to represent himself is sufficient. The name or mark of a person written by that person, written at his or her discretion, direction and discretion. And I would like to present to the international community this document as filed in the commercial registry and state the contents thereof. This document is an enabling power transaction. Redendum nunc pro tunc. Security agreement number BEAU-070565-SA. The bond demands and exacts the act of performance and event upon which it is conditioned. Remedies for material misrepresentation or fraud include all remedies available under the Uniform Commercial Code, subsection 2-701, including acts of replevin. This replevin self-help Uniform Commercial Code, subsection 9-503, transferable signatory reversion is made. Transferuntur dominia sign titulu et traditionem per usurpationem seal prolongam continuum et pacificam possessionum. Only in the capacity of third-party donee beneficiary intended to the public trust, CONUS, Continental United States of America, not under any constructive trust or derivative corporate veils of Africanus. Said signatory is a estate in reversion, to wit, the depicted seal. And is a future interest under which grantor, party of the all-seeing eye of providence, Ra and his descendants of the Nikiru nation, retains a present right to a future interest in property that the grantor conveys to another, to wit, CONUS, Continental United States, as the residue of said life estate. Also the residue of said estate left by operation of law in the grantor or his heirs, or in the heirs of his testator, commencing in possession on the determination of a particular estate granted or devised, and including but not limited to any future interest left in the transferor or his successor. A signature lithographed on the instrument by a party is sufficient for the purpose of signing it, and it being immaterial with what kind of instrument the signature is made, and whatever mark, symbol, or device one may choose to employ to represent himself is sufficient. I felt the need to reiterate that. The name of a mark or of a person written by that person at his or her discretion. Thus, in commercial law, it is any name, word, or mark used with the intention to authenticate a writing constitutes a signature. And I would like to present this instrument. to show for and on the record that this document has in fact been authenticated. Under the Uniform Commercial Code, subsections 1-207-39, subsection 3-4012, in commerce, symbolic delivery is held by construction of law as equivalent to acts of real delivery as evidence of title. Title is the act by which the rest or the substance thereof is placed within the actual constructive possession or control of another. A title is the union of all elements which constitute ownership held individually, jointly, in common, or in corporate or partnership form. Constructive delivery is recognition of the act intending that the title to property be transferred to someone even though the actual physical delivery of the property is not made because of difficulty or impossibility, and it is not necessary that delivery be manual transfer. And thus, I, His Eminence, Imperial Grand Pharaoh, having provided also in the commercial registry my private seal of rights and privies in accordance with all Uniform Commercial Code signatory requirements for acceptance of the aforementioned contract as a third-party donee beneficiary intended, as a collateral line descendant, and hereby states that in this action of declarator of trust, declarator of trust, the United States is a trust whereby the grantor retains control over the corpus or income or both, to such an extent that such grantor will be treated as the owner of the property and its income for tax purposes. The result is that the income and deductions attributable to the trust is taxable to the grantor and not the beneficiary who receives it. In this case, the United States of America. Therefore, I, His Eminence, Imperial Grand Pharaoh, a high contracting power, am not taxable, that is, capable of being charged by the United States in any enforced contribution of money or other property, accessed in accordance with some reasonable rule or apportionment by authority of the sovereign states of the United States as a person or property within its jurisdiction, for the purpose of defraying public expenses. Tax is a pecuniary burden laid upon individuals or property to support a government, and is a payment exacted by legislative authority, and as such falls in the category of charge. That is, to impose a burden, duty, obligation, or lien, to create a claim against property, to access, to demand, to accuse, to instruct a jury in matters of law, to impose a tax, duty, or trust, to entrust with duties or responsibilities, to bill or invoice, to purchase credit, to indict or formally accuse, including but not limited to all circumstances chargeable. Pecuniary means monetary, relating to money, financial, consisting of money, or that which can be valued in money. Value is any consideration sufficient to support a simple contract. Valuable consideration, and need not be translatable in dollars and cents, but is sufficient if it consists of performances or promises thereof, which the promiser treats and considers of value to him. It is not essential that the person to whom the consideration moves be benefited, providing the person from whom it moves is, in a legal sense, injured. The injury may consist of a compromise or disputed claim, or forbearance to exercise a legal right, the alteration in the position being regarded as a detriment, that forms consideration independent of the actual value of the rights foreborn. Performance is the fulfillment or accomplishment of a promise, contract, or other obligation according to its terms, relieving such persons of all future obligations or liabilities thereunder, and includes specific performance. An example given, a remedy requiring exact performance of a contract in the specific form in which it was made, or according to the forms agreed upon. The actual accomplishment of a contract by a party bound to fulfill it, and includes such terms as to conditions as to payment of the price, damages, or other relief as a court may deem just under the Uniform Commercial Code subsections 2-711(2)(b) and 2-716. And by way of my affidavit of negative averment, all past contracts between the parties in tripartite with myself, given in deodan to myself, are null and void. And by way of signature of myself, His Eminence Imperial Grand Pharaoh Ba and Nasser Nefer, cannot be proven to have entered nor accepted any contracts of adhesion to or with the United States except as stated in the Declaration of Independence of 1776. Said government of the United States is by its birth a comity of nations, by grant of the Nichiru nature nation, of which I, His Eminence Imperial Grand Pharaoh, am a collateral line descendant and third-party donee beneficiary intended. All courtesy, compliance, respect, under the willingness of my sovereign state, in grant of the privilege to these United States, was not out of a matter of right, but out of deference and goodwill. Therefore, in regards to the Declaration of Independence of 1776, is the recognition that one's sovereignty allows within its territory to the legislative, executive, or judicial act of another sovereignty, having due regards for the rights of its own citizens. I, His Eminence Imperial Grand Pharaoh, hereby state that I am under the status of privilege from arrest, to wit, on my way to any place where my duties are to be performed, while I remain there, and upon my return journey. My sovereign domain is any territory granted to the United States or otherwise ceded under the Constitution of the United States, operating 13 miles in circumference, possessio est quasi pedis, possessio, possession from the position of my foot, during its source origin, driving its source origin and being from the Declaration of Independence of 1776. Thus, any such land territory of the buyer state